All right. Why don't you make sure we're recording and we're live streaming, and then we'll go.
Yes, sir.
Thank you, Jim.
Good afternoon.
Hang on. Are we up? Okay, let me call the case and then we'll get
Sounds
started.
good.
You can stay where you are. That's fine. This is case number 24-000069-MB. Robert Davis against Jocelyn Benson in her official capacity as the duly elected Secretary of State. We're back for, I guess, what I described as round two in this case. The original complaint sought to disqualify a candidate named Kalilia Davis from running for the 36th District Court. At Mr. Davis's request, I wound up writing an opinion, removing her from the ballot and issuing a writ of mandamus that she be removed. Ms. Mindgas said in her brief that that's happened. I believe it. I check the Secretary of State's website all the time, and she has been removed. What brings us here today is a different kind of challenge. Mr. Davis filed an amended verified complaint in this case. The first three counts relate to Ms. Davis, and we'll talk about that briefly, but I'm convinced those are all moot now. What we're taking up at this point is a separate challenge in counts 4 and 5 of the first amended complaint concerning William Burton Jr., who coincidentally is also a candidate for the 36th District Court. But the route to disqualification with regard to Mr. Burton is nowhere near as clear as it was with Ms. Davis. As I understand it, and I'm sorry to give you this bit of a lead-in, but I want to make sure I have this right. Mr. Burton attempted unsuccessfully to run in 2022. In the course of his candidacy, he raised some money, and there's clear evidence of that. Now we have a statement from him too, but he was removed from the ballot, and I can't remember why, but he was. Then I guess he refunded some or all of that money. He represents that it took him under $1,000, and he obtained a filing waiver in 2022. Now he's back again 2 years later trying to run again for the 36th District Court. And Mr. Davis's challenge primarily rests on the argument that Mr. Burton raised and spent in some form or fashion, I guess returned is a better way to describe what happened, more than $4,000. And so the filing waiver was improvidently granted or lost. I'm not sure exactly what it is, Mr. Davis, but I think your theory is that he was supposed to file, he didn't file. And so the challenge now involves Mr. Burton as a candidate in the general election. I should say for the record, so that everybody knows this, because this wasn't recorded, I had a conference with the attorneys on Zoom a week or two ago. Time goes by so quickly. And they both confirmed that there are few enough candidates running for the 36th District Court that there will be no primary. So we didn't have to worry about the ballot for the August primary. Now what we're concerned about is the ballot for the November general election. And I know it's in the papers, that the drop dead date for a ruling with regard to this matter is September 6th or 7th. I suppose it depends how that works, but I'm absolutely determined to get this case finished as fast as humanly possible. Mr. Davis, I know I would certainly not invoke latches on you here. You've been knocking on the door trying to deal with Mr. Burton for some significant period of time. But Ms. Mindgas, you've indicated to me that there still was, at the time you filed your reply brief, an administrative process underway. And if you don't mind, I'd like you to begin with that, because I don't mean to tip my hand too much, but I mean, my thinking is that if this claim or these claims concerning Mr. Burton are premature because there's still an administrative process that has to run its course, I need to know how long that's going to take, because Mr. Davis is certainly entitled to a timely ruling on Mr. Burton's eligibility if he's premature now. And I tend to think that you're probably right. I don't know that for a fact. I'm going to sit down and write an opinion fairly quickly on this one. But Mr. Davis, I want to be sensitive to the fact that you are entitled to a merits ruling in this case. Okay? So, Ms. I guess why don't you go ahead and start us off, and then we'll see where it takes us.
Thank you, Your Honor. Assistant Attorney General Heather Mingus on behalf of Secretary Benson. So I think everything that the court just said seems accurate to me. And so this is our second round of summary disposition motions, this time with respect to Mr. Burton.
Can I stop you for just one
Sure.
second? On counts 1 through 3, is it your position that they're moot?
Yes.
I think in one form or fashion, each one of you thinks they're moot. And when Mr. Davis argues, I'm going to ask him the same question. So your view is counts 1 through 3 should now just be dismissed as moot.
I think that's correct. So in the amended complaint, I believe that count 1 is the MICFA, the allegation that her AOI was defective.
Correct.
For the MICFA violation. There would be no reason there's no reason at all to address that issue since the court disqualified.
Right. Mr. Davis got all the relief he wanted on what is now count 2.
That's right. Before he had even amended his complaint.
Right.
So I would agree that all of those.
Okay. So
those counts are moot, and the related mandamus count in 3 would be moot.
Right. So I think I actually granted mandamus. So I mean, he doesn't even need a ruling from me on that.
Right. You granted relief on the original complaint as to her.
Okay. So talk to me about counts 4 and 5, and along the way, explain where we are in the administrative process.
Okay. So our motion, so for counts 4 and 5, I think the easiest way to explain it, or what our argument is, that this court really has like no jurisdiction at all to make a declaration that Mr. Burton is either in violation of the Campaign Finance Act, or to make some kind of declaration that the secretary should find him in violation of the Campaign Finance Act.
Okay, well, let me stop you for a second, because
Sure.
I think I understand your argument.
Yep.
This would be no different than if somebody wanted unemployment insurance payments, and instead of going through the administrative process, they start the administrative process, and then a week later or 2 weeks later, they go to court and say, give me my unemployment benefits.
I think that's a fair analysis. I mean, before Mr. Davis had filed the amended complaint, he had started the campaign finance complaint process, which is the exclusive, remedy under the Campaign Finance Act for finding a violation of somebody. So he started that process. We're in the middle of that process. He filed a complaint. Mr. Burton has filed a response. I don't know if Mr. Davis filed a rebuttal.
Yes.
He's filed a rebuttal. So what I learned today was we're kind of now in this 45-day window by which the secretary has to issue some kind of, initial determination of what's happening here. So that could be at the end of this, it could be at the end of the 45 days, it could be, I don't find any violation, or it could be, there's reason to believe that Mr. Burton is in violation of the Campaign Finance Act. And if that's true, then it kicks off the conciliation process that's required. So the secretary has to endeavor to conciliate or rectify a potential violation.
And how does that work? I think the way you explained it in your brief, it sounds like even if he's out of compliance, there's a possibility that he could be allowed to bring himself into compliance
Correct.
without a finding of any sort of violation.
That's correct. That would happen if both parties agreed to enter essentially into a conciliation agreement. And that conciliation agreement resolves whatever alleged violation there was.
How would that
It's kind of like a settlement, right? It's sort of like a settlement.
Well, how would that affect his eligibility for the ballot, though?
I don't think it does, because as we noted in our brief, obviously the court's not bound by attorney general opinions, but
Sure.
the AG had just issued an attorney general opinion not long ago, because this has come up. If you've successfully conciliated something, that it's not a violation. It removes it from being a ground or a basis for trying to knock some off the ballot under, the MICFA false statement affidavit in 558.
Is there a possibility that Mr. Burton could be removed from the ballot by your administrative process? The reason I ask the question is, no. Okay.
Because we don't have that authority under the campaign finance side. It would be, then a question would be like, what what steps would the Secretary of Bureau of Elections take on the election law side? If there was if we can't conciliate though, right? If it goes to conciliation, we can't reach an agreement. The steps after that is that either if there's a criminal penalty, it would get referred to the AG's office for a prosecution, potential prosecution. If we don't do that, then it proceeds to an administrative hearing where then there is a final decision up or down on a violation.
When you say up or down, and I know you're an expert on this, how would that affect his eligibility to run for the 36th district court if they find that there's a violation, that he should have filed a report?
I think, and we didn't really brief this issue. I think our position this position would still be, and I'm going to hedge this a little bit because I haven't talked to the client or anything like that, but the 5584 or 558 requires them to file a statement that's accurate at the time that he files the AOI, right? Your AOI has to be accurate at the time you file it. Our position has always been that it was accurate at the time you filed it because there was nothing due and owing, right, in the campaign finance filing. So our position would be you can't retroactively finding a violation now 4 months after he filed the affidavit. We don't get a retroactive finding of a violation preceding that. But okay. I want to hedge all that. I think we haven't written that part yet. We're not to that part yet, right? Because we don't have any decision one way or the other as to Mr. Burton.
Right. So the way you interpret the state law, the relatively new state law about how all this works is when you sign your certification, you're merely signing a certification based upon the facts on the ground as they exist at the time you sign the document.
Right.
So it's kind of the flip side of if a statement on there is false when you sign it, you can't fix it and then file a new one. This is the opposite of that. If you're fine when you file it, nobody can go back and render it a false statement.
I think that's a fair summary of that, yes.
Okay. So this entire administrative process then is never going to produce the result that Mr. Davis wants, which is disqualification.
Not the MICFA side of the process, right? If we get all the way down the road at some point and there's an actual determination that he violated the Campaign Finance Act, despite everything I just said, I think our position would be what I just told you, right? But I haven't conferred with the client. What would we do anything on the election law side with that? And I don't think that we would, for the reasons we just said. There's no retroactive application of a violation. We're finding it 3 months now. We're not going to apply it to an AOI that was filed in April.
Well, I presume that the secretary has to put her blessing on every one of the candidates for the general election. Yes?
Right. So on September 6th, so the last day, what gets sent to the counties is sort of after the Board of State Canvassers does its thing, it's got any issues, there's a certification that goes to the counties. So it would go to Wayne County and say, here's everybody who made it through the primary, or here's everybody who should appear on the ballot for these races. So it gets down to, I see what your honor is getting at. I think, and I did think about this a little bit. I agree that you don't get a disqualification through the MICFA process. I suppose theoretically what could happen is if we find a violation and we choose not to disqualify him for the reasons I already said, Mr. Davis would be free at that point to, bring some other additional action to make an argument to this court that I disagree with Ms. Meingrass' argument that there can't be a retroactively bad or false affidavit, and that this should be grounds to disqualify him now.
Right. You're reading my mind, because if there's an administrative process underway that's going to yield a final answer within a reasonable period of time, and that answer will then allow Mr. Davis to go forward, I'm happy to wait. But if we're not waiting for anything that's ever going to happen, if this could take 6 months, or if the end result couldn't possibly be removal of Mr. Burton as a qualified candidate for the 36th District Court, I don't know why I'd be waiting.
I think the problem would be that this court has no jurisdiction to clarify.
Right, I got it. But in the ordinary course of things, there's a final result produced by the administrative process that an aggrieved party can then appeal. That's one thing.
Which will happen here.
Right. And the other thing is there's usually not a timetable on it. I mean, if I'm seeking unemployment benefits or a license or something like that, there's no absolute drop dead date on it. I mean, if I get my unemployment benefits 2 weeks from now or 2 months from now or 2 years from now, I can get all the relief I'm seeking. Here, it seems to me, once the Secretary of State certifies on September 6th, there's really no relief I can grant, I don't think. Because even if I were to issue an order on September 10th saying remove him from the ballot, I think your response would be too late, can't do anything.
Sorry, Your Honor.
That's okay.
I'm looking because there is a timetable, right, for resolving a complaint, right? We're in the 45 days right now, and I think, you know, the time where there might be a delay is by the 45th day. We have to decide whether there's any violation, or if there is a potential violation, then it goes to conciliation. And where I don't think there is a specific timeline is how long conciliation has to take.
Okay, but I think your fundamental position is, even if I may not be able to get a decision out in time to provide the relief Mr. Davis seeks, that's not really something that he can do anything about or I can do anything about. If I have no jurisdiction, I have no jurisdiction.
I mean, as far as not being able to get a timely decision, Mr. Davis could have brought this MICFA complaint anytime within the last 2 years, right? If the violation occurred in 2022, he certainly didn't have to wait until in June of this year to make a MICFA complaint against Mr. Burton.
And I think I understand what you're saying, that in the case of Mr. Davis challenging Mr. Burton, I've always taken it as an article of faith that he moved as quickly as he could, because as soon as it was evident who was going to be a candidate for the 36th district court, he added Mr. Burton to this. Your response to that would be, no, that's not the way to look at it. What he's trying to do is he's trying to challenge something that was supposedly wrong in 2022. So he's been waiting 2 years.
I think that's right. I mean, he filed a lawsuit quickly. I don't disagree with that, right? But this purported violation obviously occurred, you know, two years ago.
Okay.
And it was something that could have brought, you know, well before June. And, you know, or Mr. Burton filed his affidavit in April, right? The campaign finance complaint could have been filed in April. So.
All right. So in other words, it is your firm belief that I lack jurisdiction, and regardless of how much concern I might have about Mr. Burton's circumstances, because he clearly raised over $1,000. I mean, I read his response, by his own admission, he did.
Right.
But in your view,
something for the secretary to resolve as to whether that's actually a violation or not.
Right. And I'm certainly not accusing Mr. Burton of a violation, but at least it's a circumstance where there is cause for concern. It may be in the view of the secretary that it's really no big deal after all, but
I don't know, it's a big deal. I think we have to, what is the purpose of section 558 and subsection 4? I don't think that the legislature intended this section and these campaign finance affirmations to be weaponized the way they're being weaponized, right? If you've made a mistake on your campaign finance filings, then you've made a mistake, right? But at the time that you filed it, there was nobody had told you that you'd made a mistake, right?
So, all right, and I take it that your approach to the validity of one of these verifications, the affidavits that you file, is it's binary. You just go look at what the circumstances were on the date the person signed it, and they either are out of compliance by something you can confirm in the moment. It doesn't require digging or analysis or evidence.
It's consistent with the rule, the administrative rule.
Or they're not in compliance. And if they're not in compliance, you will take the action to disqualify them. And if there's no evidence from your records that they're out of compliance, then by definition, they're in compliance.
That's correct.
Okay,
That's
I understand.
correct. Right. If they had looked at Mr. Burton's filings and there had been a line entry showing he has a late fee due, then he would have been disqualified. Right. Or a report due, he would have been disqualified. But there was no such entry.
Right. And I certainly know that the secretary exercises that authority. I've seen that happen in lots of cases.
Yes,
where they're
right. Yeah.
disqualified.
And we look at the Campaign Finance Act requires the secretary and her staff to look at everybody's reports as they come in. So it's not like people file a report or filing and nobody looks at it, right?
Mhm.
Reports are filed and they do get looked at. So it's not like we're putting a bag over our eyes and not looking at filings.
Right.
That is a
And
requirement.
one of the reasons I asked the question is that Mr. Davis made a request to conduct some discovery, and it struck me that discovery really isn't the right mechanism to get to the bottom of something. The right mechanism to get to the bottom of something is the administrative proceeding that precedes the court action, because presumably once the case lands in the lap of a judge on the Court of Claims, the facts are supposed to be clear.
Right, like we would have an administrative record.
Right, because I was amused reading all this last night at how we have an evolving factual context for this case. Because now Mr. Burton has filed his response and we see what he has to say. And he essentially admits, yep, I raised over $1,000, but then when I got knocked off the ballot, I sent it back, and when everybody cashed their checks, I was back under $1,000. Now, whether that's in compliance or out of compliance, your view is when he signed his affidavit, he was in compliance.
When he signed his affidavit, there was nothing in the campaign finance filings to indicate he was out of compliance or owed any reports.
Right.
I think there's a nuance there, Your Honor.
Right. I agree. Look, when you sign off on a candidate, you're not giving them the good housekeeping seal of approval that every single thing they've done all the way along the line is clean.
Because anybody could have made a mistake that somebody didn't identify.
Right. Okay. All right. So in simple terms, you have two basic arguments. One, go away, judge. You have no jurisdiction.
I didn't use that word.
No. But I mean that sincerely. And I'm a big believer in doing what the law tells me to do. And if the law tells me to go away, then I go away. However strongly I may feel about the merits of the case. So argument number one is the threshold question of jurisdiction. There's an administrative proceeding which is in progress, and unless and until it's resolved, I have no authority to take any action. And then the second argument is the one that you and I have, it's a discussion you and I have had before, that your view is as long as you are not out of compliance when you sign the affidavit, you're good to go, and nobody gets to go back and unearth some mistakes you made along the way and try to essentially disqualify you nunc-pro-tunc.
Or at least not through, yes, I think that's right. I mean, not through a court proceeding. I mean, everything needs to be funneled through a MICFA proceeding, an administrative proceeding.
So in other words, you're telling the court system, not in a rude way, but you're telling the court system, we have the fact finding under control. We will run what we deem necessary to engage in the fact finding. Then after we've done our best to try to sort out the situation, then somebody can come and ask the Court of Claims.
Right. I think there would be a question then as to whether that would be sort of this retroactive idea of whether today's violation disqualifies him back to April. Right.
I mean, and obviously we are digging into these issues at a level of sophistication that I don't think anybody anticipated when we got started with this process, when the legislature passed the statute. I don't think they ever would have imagined that there would be
I think that's true.
All these challenges at this level of sophistication.
I think that's true. Because if you look at section 558, obviously it doesn't contemplate any kind of court action at all other than a potential prosecution for perjury, right? So the idea that we're now seeing multiple court actions to disqualify people on the MICFA front is, I'm not sure that was within what the legislature intended to sort of weaponize it. What the legislature intended is like, candidates, do what you're supposed to do, file reports, pay fees, and put your John Hancock on there and affirm that you've done it, right? And if somebody's done that,
Right. The context for the legislation.
The perjury part, I mean, the punishment is perjury, right? It's a perjury
Right.
prosecution.
The context of the legislation, as I recall it, is a whole bunch of people had all these fines they piled up and they were just ignoring them.
Yeah, I think that's right.
They continue to run for office. They continue to get reelected and they never, ever paid their fines. Okay.
All right.
That's really clear. And I'll give you some clean air to say anything else you want. I promise I won't interrupt, but you've been very helpful.
I don't think so, Your Honor. I think we've covered everything. Unless the court has questions about, Mr. Davis had responded back to our motion that he has jurisdiction under the section 64 of the APA. I responded to that in the reply brief. So I'm happy to make way for Mr. Davis.
Okay, thank you. Mr. Davis, if you'd indulge me, come on up here. Let me ask you a couple of questions first, and then I'll let you tell me anything you want to tell me. First of all, with regard to counts 1 through 3, do you agree that they can be dismissed as moot? You got all the relief you wanted?
With respect to counts 2 and 3, you've granted the relief. And the only thing I was saying with respect to those counts, that in light of your previous decision in order, that summary disposition should be granted with respect to those 2 counts based upon your previous opinion.
Well, I'm a little confused about the procedural posture right now, because I think I saw an order signed by Judge Borrello in his capacity as Chief Judge Pro Tem.
Dismissing the appeal.
Yeah, she tried to appeal or something, but she's a non-party, so it got dismissed because she's not a party, so she has no right to appeal.
In addition to the fact that the order, your opinion in order, was not a final order, that she could file a claim of appeal. So as me and Ms. Meingas, I was thoroughly confused when we received the filing from the other attorney on her behalf. So now that the appeal has been dismissed, which you raised concern during the status conference.
Right, I can't act if something's on appeal.
So now it's dismissed. Now you have every right to, so that whatever decision you make in this case, it can be a final order with, as it relates, you can address the issues with respect to Ms. Davis in counts 1 through 3.
All right, I see what you're saying, that you want me to come back around and essentially confirm in a final judgment or a partial final judgment what I already did on counts 2 and 3, because I haven't done anything with count 1.
And I agree with respect to count 1, that count 1 is moot in light of your decision with respect to counts 2 and 3 already. Okay,
well, I'm going to give Ms. Meingas another chance to comment on that, because I hear what you're saying and it makes a good deal of sense to me. And as you recall, when we had our off the record conference, I was concerned about doing anything where I didn't even have jurisdiction to act because the matter was in the Court of Appeals. And now that Judge Borrello has dismissed the appeal, I guess you're right. The ball's back in my court if I want it to be.
Indeed. And I think just procedurally, so that everything is one way or the other, all claims would be clear based upon your decision on all counts. And based upon your previous ruling on counts 2 and 3, it would be, to me.
So there would be a final order, which I guess I could describe as a partial judgment, dismissing count 1 as moot, granting summary disposition to you on counts 2 and 3, indicating that with regard to all claims concerning Kalilia Davis, it's a final order that resolves the last pending claim and closes the case, which is the magic language if somebody wants to try to go to the Court of Appeals.
Correct. And of course, with counts 4 and 5, you're going to, one way or the other, deal with those.
Right. So let's talk about those, because I will concede at the front end that you have raised what I would describe as an issue of significance. I'm not saying you win because of it, but I think you don't really need to do any more discovery, because I am taking as an article of faith now that Mr. Burton attempted to be a candidate in 2022, raised more than $1,000, and then had to dispose of more than $1,000. I don't think you can raise $5,000 and then send it back or send it wherever you want and say, see, I'm under the $1,000 threshold. So I get that. So I hope that you don't think you need any discovery at this point.
Your Honor, I think in a communication that I responded to his response
Right.
to the campaign finance complaint, that basically his admission and the secretary's response to the motion that basically they don't dispute the GoFundMe records.
Right.
They've confirmed that that existed, and he's confirmed in his response that it existed. And so there's no need for discovery. So I'll withdraw my motion for additional discovery or evidentiary hearing because the court is going to admit as evidence.
Okay, great. So I'll indicate that that motion is simply withdrawn. I presume, Ms. Meingas, you have no objection to it being withdrawn, just in case we need to clean it up. That's your position, yes? Okay, thank you very much. So that's what I'll do with that. And I want to be clear before we start our discussion about what's in front of me now, that I believe you have laid the factual predicate to make the argument you want to make. Now, whether the argument you want to make is one I can even touch because of jurisdictional issues, or whether you can go where you're trying to go. I mean, you're really trying to carve out a new frontier in these challenges.
No, Your Honor, actually, I'm not.
Well, is there any other case where this has happened?
Absolutely. And this is, I was trying to be composed in listening to Ms. Meingas' arguments, because the reason why 558 subsection 4 was amended, I was a staffer in the legislature. The reason they amended it, it goes back to a case that I brought in front of Judge Kinney from 2000, in which Secretary of State Candace Miller was the Secretary of State at the time, in which I brought a challenge against Ricardo Solomon in Wayne County. He was running for Wayne County Executive, and former State Senator Joe Young Jr. was also running. Mm-hmm. And the two of those candidates had an abundance of late campaign filings. Both.
A lot of people had a lot of those. You know, Ms. Meingas knows, I know, right?
And the way in which 558 was written at the time, it did not include the additional language of the consequence. So what former Chief Judge Kinney ruled, and the Court of Appeals affirmed him, was that the legislature did not carve out in the statute a consequence for lying, that the only consequence was being charged with perjury. So the legislature, a few years ago, while I was a staffer in the Michigan legislature, I provided my insight on those issues with respect to the need to provide a consequence. The consequence now is that if there's a false statement, or if there's any information on that affidavit that you failed to provide, that's mandatory, you cannot be certified by the filing official.
Right. And I think you're absolutely right about that. The question is, if they sign a verification or under penalty of perjury statement,
absolutely,
and they're not out of compliance. I can't say they're in compliance. They're not out of compliance.
No. Here's the reason why the caveat is very significant, because now filing officials, it's not the onus. And if you look at Burton Harris versus Wayne County Clerk, which is the case that I was a part of,
you've made a lot of law statements
on this issue. They make it abundantly clear, because the argument that Ms. Meingas and others successfully argue over the years was that the county clerk or the Secretary of State cannot go beyond the four corners of the affidavit. We don't have, the statute doesn't give us investigatory powers, so on and so forth. It's the four corners, and if based upon what we have, that's all we could go. And that panel said, no, 558 subsection 4 now allows a plaintiff through declaratory judgment. Some people make the mistake and only ask for a mandamus. That's why I asked for a declaratory judgment first, because I'm asking.
You're very wise. It's easier to get than mandamus.
I'm asking the court to declare whether or not this candidate submitted a truthful affidavit based upon a factual record that I'm presenting to the court. It's up to the court now to determine, based upon that factual record, whether or not that candidate's affidavit of identity is truthful.
Well, if you're right about that, and you may be right about that in the final analysis, but in the first instance, doesn't it have to go to the Secretary of State to make some sort of determination before it comes to us? I mean, I don't know how we would be fact finders in the first instance in every one of these situations.
In the Burton Harris case, the court said no. And that was the reason why they said, you don't have to, I don't even have to file a challenge. And that's what the court made clear. You do not have to file a challenge with the filing official and wait for them or the respective election commissions to make a decision. Once that candidate filed that affidavit and you feel there's some defects, you have standing to come before the court immediately. And that's what their direction was in the Burton Harris case.
Right. And you say that's a Court of Appeals case?
Yep. And it was vacated in part on other grounds by the Michigan Supreme Court. On other,
okay.
The portion of the opinion that remained intact describes that.
I see what you're saying. So what you're saying, it was vacated as to some issues, but not that.
Correct.
And so it remains
because they reached the merits, despite the fact finding that the trial court was affirmed that I should not have been allowed to intervene as a plaintiff. And so because they affirmed the denial of my motion to intervene, the Supreme Court said they should not have reached the merits in certain parts of the opinion. But if you read their opinion, it makes crystal clear, which is why you've had an abundance of cases over the last 2 years brought before the court challenging various candidates in various races because they filed false affidavits of identity. And here, Your Honor, this, with all due respect to the Secretary, the Michigan Campaign Finance Act is not the process by which to address the question under 558. I simply go through that process just to check multiple boxes so that
right.
all areas are covered. In this case, Your Honor, because I knew the various arguments that the Secretary has made in the past, I filed a campaign finance complaint, even though I didn't have to. I filed a request for a declaratory ruling under the APA, which they denied.
Right.
And I also followed the Court of Appeals instructions in Burton Harris by filing a declaratory judgment in this court based upon the factual record that I had to show that he was required to file statements during the 2022 election cycle that were not filed as of the date he signed his affidavit of identity.
Well, let me ask you a question, Mr. Davis, because in Mr. Burton's response, he alleges latches, but he approaches it the way Ms. Meingas does, that you could have challenged back in 2022. Who makes the decision on whether latches applies? Do they or do I? Because I have to say, when I first picked up this case, I sized it up the way you did. But now, having read Mr. Burton's response and heard Ms. Meingas' argument, I wonder whether you and I are right about that.
We are right. And latches does not apply in the campaign finance statute. Simply put, I can go back 5 years and find a mistake someone made and file a campaign finance. There's no limitation of period that you can file.
Well, there's clearly no statute of limitations. I agree with you on that.
There's no limited period in which you can say, you can only file a campaign finance complaint for this specific period of time. And in this case, Your Honor, his campaign finance issue would not be an issue had he not become a candidate. Here, the issue here is whether or not he submitted a false affidavit of identity.
I see. So what you're saying is that the violation was not complete until he signed the affidavit.
That is correct.
In other words, if he was out of compliance in 2022, it was of no significance whatsoever.
Because he was removed from the, and the reason why he was removed from the ballot, it was a case that I was a part of, is that the reason why you have a changed affidavit of identity. He left the space blank.
Oh, the no party affiliation. Right. Oh, right. Believe me, I was the president of the Michigan Judges Association. I had people calling me all hours of the day and night about that.
So once he was removed from the ballot, he admitted in his response that he returned, as well as he should, the contributions he received. The issue didn't become relevant until he submitted a false affidavit of identity. So now it's incumbent upon this court under 558 subsection 4 to declare whether or not he submitted a false affidavit of identity based upon the undisputed factual record before the court.
I understand what you're saying.
The secretary's position that no, this issue has to be resolved through filing a formal campaign finance complaint is absurd, because it would render 168.558 subsection 4 meaningless. I mean, if that's the case, then every case that has been litigated over the last 4 years under this new subsection, the court didn't have jurisdiction to make that determination, which is simply not so. The course of action based upon the Holden and Burton Harris, and I want the court to also look at the case of Roca.
Okay, I'm sorry, let me write that one down.
Roca, R-O-C-H-A versus the Secretary of State. It was 2022 case. And that was a very interesting case that went to the Supreme Court, where you had this candidate who had received a notice of a late filing fee that was not due until sometime in the future. But as of the date he signed the affidavit, even though the due date was in the future, that late filing fee had not been paid. And according to the Secretary of State, he was in compliance because the due date was, it wasn't due. And the Supreme Court said, no. As of that date, even though that late filing fee was not due until 2 weeks later, as of the date he signed it, he was out of compliance. Everything was not in order. It's the same principle that applies. Same principle. Here, on the date in which Mr. Burton signed the affidavit, he attested that all statements and reports required of my committee have been filed. That's not the case, because he did not file any of the 2022.
Right, and I think nobody disagrees with what you just said. He did not file anything in 2022.
Right.
He got his reporting waiver
after the fact. And what's alarming and concerning, and he's a magistrate, but he got the reporting waiver on the eve of the due date of the reports. And by his own admission, he knew he received over $1,000 in contributions. Whether or not after he was disqualified and then he returned some of the contributions is immaterial, that it fell below 1,000.
Yeah, I don't know for sure, and I've got to go back and take a look at that, but I'm pretty sure you're right about that, because as I recall the way the canons work, you have to return any money that you have unspent at the end of a judicial campaign, but I don't think that affects the collection threshold.
No. And the statute is self-execute, which is why I, for the life of me, I don't understand. And I understand the Secretary's position, because she believes, we disagree a lot. She believes that this is being weaponized and used to attack candidates that I disagree with, or whomever disagrees with. And I said, no, the statute is the statute. Just because you disagree with the language of the statute doesn't mean you could go try to promulgate rules to circumvent the legislature. It's what they're attempting to do, which is what they have done.
Well, right. And I remember, I've had so many of these election cases. I can't remember whether it's you who raised it with respect to Cornelia Davis or somebody else who raised it, but this.
Oh, your infamous concurrent opinion about state.
Oh, I'm not upset at all about the people, about the people. No, what I said in my concurring opinion was I wasn't frustrated at all with the people who litigate. I was frustrated with the judges who are calling in airstrikes on their opponents. That's what I got upset about. I mean, in the same way that I have nothing but praise for people like Steve Liedel and Mark Brewer and all the people who litigate these cases, you're the same, Mr. Davis. I mean, you're not trying to run for judge.
No.
You're not a guy on the ballot trying to take out all your opponents. So if I had to characterize you on one side or the other, the group I praised and the group I criticized, you would fall on the side of the group I praised.
Oh, thank you.
The people I criticized were the ones, and I've seen this happen. That's what drives me nuts is you get your stuff, you file it, and then immediately you pull all the signatures of every one of your opponents and you start going through them and trying to figure out how you knock off everybody else so you have an uncontested election. That's the one and only point that I was trying to make. That
it came through crystal clear.
Well, I was hoping you weren't overreading it because I wrote a paragraph where I was very clear about the fact that I have nothing but respect for the people who master this area of the law. I mean, it's like anything else. If you're an advocate in one of these cases, you're trying to win the case, and that's fine. Nothing wrong with that.
No, and here's the issue that collides with the secretary's position. 168.558 subsection 4 now has a consequence. We're not asking the Secretary of State, as illustrated in Burton Harris versus Wayne County Clerk. We're asking the court to declare whether or not Mr. Burton submitted a false affidavit of identity.
Right.
And this court has jurisdiction to do so. There's an actual controversy. Thus, under MCR 2.605, this court has jurisdiction. This issue under 168.558 cannot be resolved through the campaign finance process.
Let me put it this way. Assuming I have jurisdiction, I have no trouble getting to the merits in this case. I've gotten to the merits in every single one of these election cases I've had. I'm not trying to duck making decisions on the merits, whether they're disqualifying decisions or authorizing decisions.
No, I just wanted to address her jurisdiction issue.
I understand. Yeah. Right. But I mean, her position is that there's an administrative process and you have to exhaust the administrative process before you can walk into court. And that, I'm sure you know, for judges, that's a well understood principle, that if there's an administrative process, you have to go through it first.
And let me address those.
Right. That to me is what I'm really struggling with.
The administrative process that the Secretary of State cites is if you want to find a violation of the Campaign Finance Act. In order for the court to reach the merits of whether or not Mr. Burton submitted a false affidavit of identity, this court does not have to make a declaration that he violated the Campaign Finance Act. Court simply makes a declaration of whether or not he submitted a false affidavit of identity. Did he have everything filed as of the date he signed his affidavit? Just like in every case.
Right, but isn't that 6 of one, half dozen of the other? Because what you're really saying is I've got the jurisdiction and the legal authority to dig into the facts of his situation and essentially countermand the interpretation of the Secretary of State that they simply conduct a box checking exercise to make sure fees are paid, fines are paid, reports are filed.
Let me share this with you, Your Honor. It's no different for when it's been brought to the Secretary's attention when they've improperly certified candidates that the candidate 10 years ago ran for a different position in a totally different jurisdiction and had issues and said, your certification was wrong. Look, which is another reason why they changed the affidavit of, I'm not going to go there, but when you bring information to the attention of the court or the filing official, it doesn't make you have to make a determination that they're in violation of a particular section of the Campaign Finance Act, which is what they're saying. In order for you to enforce that provision, that has to happen. And if that's the case, then the 30 cases that have been litigated, the court didn't have, the court didn't have jurisdiction. And in every case, in fact, the court delved into explaining the provisions of the Campaign Finance Act.
Right. So in other words, they can't be the exclusive gatekeeper.
No. And then the other case you need to refer to is Reed Pratt versus Detroit City Clerk, which dealt with whether or not amendments to campaign statements were inclusive in the prohibition. In that case,
are you talking about the situation where you sign an attestation that's false? In other words, you owe $500, and then they tell you you can't do this. You owe $500. Then you go pay the $500, and the next day you file an amended.
No, in that case, what was interesting in that case, what happened was the candidate for Detroit City Council not owed any late filing fees, but she did not file certain amended reports based upon.
Oh, okay. So instead of paying fines or fees, it's failing to file reports.
Right, amended reports.
Okay.
And in that case, the Court of Appeals clearly, they delved into the campaign finance provisions as to determine whether or not do amended reports are included in the campaign compliance statement, where it says any and all statements, reports have been filed. And the Court of Appeals said, yes, that's included in any. Because the argument was being made, amended reports are not included, only the original reports. And the Court of Appeals said, no, if they're required to file an amended report and they had not filed them, that applies. And in that case, the Court of Appeals delved into the campaign finance provisions and analyzed the Campaign Finance Act. And in their analysis, they said, well, the only way that you can disqualify a candidate if they failed to file an amended report is if the filing official, being the Secretary of State or the county clerk, properly submit or issue an error or omission report under the Campaign Finance Act. And if they didn't follow it explicitly, meaning sent it by certified mail within 5 days, and then that candidate is under no obligation to comply with that error and omission report, and they cannot be disqualified. They analyze the Campaign Finance Act. If you take the secretary's position, then every instance where you're challenging the truthfulness of the affidavit based upon compliance with the Campaign Finance Act, they're saying, nope, Judge, you don't have jurisdiction, is left exclusively up to us through the Campaign Finance Act, which is not the case. 558 gives this court jurisdiction. And let me address that administrative procedure. The two cases that I cite, Your Honor, they don't make a determination. And that's why I provided an example. I attached their decision with respect to my issue with the Third Circuit Court. They don't issue a determination as to whether or not a candidate violated the Campaign Finance Act. And as indicated in that opinion of
oh, I know what you're talking about. You're talking about the attachment to your response. Hold on, I'll get it. I know exactly what you're talking about. The April 7, 2023 letter to Donald Campbell, attorney for Julie Dale and Richard Lynch, right? That's what we're talking about?
Yes, yes, Your Honor.
Yep.
And if you examine the language that the secretary uses, they say may have occurred. A violation may have occurred. And the Court of Appeals said that's significant because that's not a decision. They don't make a decision. And what the Court of Appeals clearly indicated is that if you want them to make a decision under the a declaration under the Campaign Finance Act, you have to file a request under the APA for them to issue a declaratory ruling. So this process that they're undertaking is not going to resolve the question.
Right. I think and that was the question I was asking Ms. Meingast, and I think that you two may have told me the same thing, that there's a very good chance that as they work their way through the administrative process, one, it will take a long time. Two, there may never be a determination that you could, in effect, appeal to the Court of Claims.
And the two cases Citizens for Common Sense in Government versus Attorney General, and Huron Violence Schools versus Secretary of State. They go through it specifically and said, you can't appeal that letter, which is the same boilerplate letter they issue in every case, because they don't make a decision, because they always say may have violated.
So at the end of the day, what you're telling me is the administrative process doesn't produce an outcome that you can bring to the court.
No.
So you have to file your own action and initiate the decision-making process in the court system.
Indeed. And under the amendment under 168.558 subsection 4, it allows the court to make those determinations. And more importantly, Your Honor, I followed the instructions of the Court of Appeals in both of those cases I just cited.
Yep.
In which I asked them to issue a declaratory ruling. They denied it. And under those holdings, I have the right to seek a declaratory judgment standing before this court too. So not only do I have the right under MCR 2.605 and 168.558 subsection 4, but I also follow the instructions given by the Court of Appeals when they said, if you want the secretary to issue a declaratory ruling with respect to campaign finance issues, request it under the APA. And if they deny you, then you have standing to seek a declaratory judgment before the court. I did that. But again, you don't have to find that he violated the Campaign Finance Act to determine whether or not, to make a determination if his affidavit is truthful or not. I know you truly don't.
Well, let me put it this way. As I've indicated, you've laid the factual predicate for the argument you want to make. The question is, can I act now on that factual predicate, or must I stay my hand until whatever this process is runs its course?
And the answer to that question is no. And the courts have given you that authority. And I mean, the Burton-Harris case addressed that issue head on, because they said, Mr. Davis, we appreciate you submitting a challenge to the clerk and the election commission, but you didn't have to. You could have came straight to us right off the get. Once you saw that there was an issue with that candidate's affidavit.
Right. And to the extent that they would argue that there's value in going through the administrative process, your response is, first of all, it won't produce a result that I can challenge. Second of all, I already have the facts in hand to make the argument I want to make. What's the point? There's no need for administrative fact finding, because we already know what the facts are.
Exactly. I mean, and if you had to go through that administrative process, which you do not,
right,
there would not be any case that would have been able to be litigated.
Well, right. The other thing I wonder about, and I know Ms. My guest will have an answer to this, but ordinarily, if you are proceeding under the APA and you have to get an administrative decision as a precondition to go to court, going to court means going to a circuit court, not the court of claims. And I think your point would be, a lot of these cases are initiated in the court of claims. How did that happen if this is impermissible?
With respect to that, I mean, to answer your question, I mean, the Court of Claims clearly has jurisdiction with respect to the secretary.
Absolutely.
And with respect to the Court of Appeals decision as it relates to campaign finance issues, based upon the legislature's infinite wisdom of saying that this court has exclusive jurisdiction for whatever political reasons at that time over state agencies, this is the only court that can address it. Okay. With respect to the secretary. And here, I mean, I checked every box so that they couldn't delay either way. If you said this way, I did it that way. If you said this way, I did it that way. I learned from my mistakes in the past in trying to trust our public servants, but Your Honor, I made sure knowing their arguments, I tried to cover every base. Right. And I did that here. And I think the record is clear that this court has jurisdiction to act with respect to the fundamental question of whether or not Mr. Burton's affidavit of identity contains a false statement as it relates to his compliance with the Campaign Finance Act. And based upon the undisputed evidence in the record, it's clear that his affidavit was false because certain statements that he was required to file were not filed. And just lastly, Your Honor,
Sure.
I mean, which is
Sure.
very important. MCL 169.233 subsection 6 of the Campaign Finance Act is self-executing, which is why it doesn't.
Say that again, 169.233, which?
Subsection 6, which governs the.
I'm sorry, 169.233 subsection 6. Sorry, I got the numbers.
No, that's okay.
Mangled there. Okay, I got you.
That section governs the filing requirements in the reporting waiver. It's self-execute, where it says a candidate committee that files a written statement under section 24, subsection 5 or 6, or that is automatically considered to have made a statement under section 24, subsection 5, is not required to file a campaign statement under subsection 1, 3, or 4, unless it received or expended an amount in excess of $1,000.
Yeah, okay. I know exactly what you're talking about. I'm with you.
And most importantly, it goes on to state, if the committee receives or expends an amount in excess of $1,000 during a period covered by a filing, the committee is then subject to the campaign filing requirements under this act.
All right, and just to be clear about that, because it's in the disjunctive, expends or receives. So if either one of those happens, it triggers the obligation. And even if he sent every dime back, if he received more than $1,000, game over.
Game over. And by his own admission and by the other documentary evidence.
Right. And
so why the secretary is attempting to defend that, I mean, for the life of me, I don't understand it. It's not a weaponization against candidates. It's making sure that they comply with the statute. And here, this candidate clearly. Now, what the repercussions are, the Secretary of State has jurisdiction over that in terms of assessing fines or requiring.
Sure. Or having a conciliation process and just letting it go.
And to address that conciliation process, that has no bearing. I know that's going to get challenged because once again, even if a candidate complies with that, that's after the fact. It's based upon the date in which they sign the affidavit.
Right. I mean, now we're coming back to that same simplistic example that I mentioned where somebody's got an outstanding $500 fine, they sign, submit, and then they're notified or they figure out they owe the money, then they try to pay the money and file an amendment. In other words, some mistakes you can't fix because you've made the false statement already. And your position here is no conciliation process can absolve somebody of the responsibility for making a false statement.
Correct. And lastly, Your Honor, and then I'll take my seat.
No, it's fine.
Here's another example that goes against the Secretary's position. If a candidate, one of the mandatory provisions is that the candidate has to provide their address, their residence address, right? You've had situations where people have put a false address.
Oh, sure. Yes. There have been people knocked out of office.
Right. And based upon that, the Secretary's position, well, we checked all the boxes. They put their address. We can't go back and check to see if that's the real address. But once information is provided that address is fraudulent, the courts have been quick to step in and say, nope, you're disqualified. So again, that just goes to the jurisdiction of this court when you have the facts to make a declaratory judgment.
Okay, I understand. Thank you, Mr. Davis.
Thank you.
It's my guess that there's a lot out there, so I'll let you start wherever you want to start. But I would like you to talk a little bit about the Burton Harris case because I will confess I planned to write an opinion in this case. I did not go back and read all the cases, and there seemed to be a disagreement between you two about what the Supreme Court vacation of the Court of Appeals decision is. Mr. Davis says it was vacated on other grounds, and when that happens, of course, whatever wasn't vacated remains binding precedent. But if they vacated that particular aspect of the decision, then it's not worth anything.
Well, first, I would like to note that none of these cases were cited in his response.
That's why I was furiously writing.
Right. And when the last time I looked at, because I did look at Burton Harris, because it does say what he's talking about. The court did say that, and it's been vacated. The only thing that survives from the Court of Appeals Burton Harris decision after the Supreme Court is the analysis of the intervention.
Okay,
Everything else
so
is
you concede
vacated.
that some part of Burton Harris from the Court of Appeals is
Just
still
the
viable.
intervention piece.
Okay, I got it. I'm just trying to understand,
Yeah, that's
because
okay.
I'm obviously
I had
gonna,
to think
the
too.
first thing I'm gonna do when I start working on this opinion is read Burton Harris from the
Right.
Court of Appeals and then read the Supreme Court order.
And as far as, Roca's not on point at all. Reed Pratt, he didn't cite that one, so I'm not really sure about that one, so I can't
Right,
address that
I'll track
one.
these down,
So,
but yes, I
if
hear
the
you. But
court, if we need to, I'd like the opportunity to submit supplemental briefing if the court thinks there's a case that's on point or dispositive that we haven't had an opportunity
Right,
to.
let me put it this way. I don't even know where I would direct you to go if you found supplemental brief, because I haven't
Well-
read these cases. I don't know what they say. I mean, for example, you say Roca is totally off point, and you may very well be right about
It
that.
is.
So I don't want to brief on Roca if it
Right,
does.
so Roca was one of our cases, and Roca we disqualified. So we made a decision that he was disqualified, he was one of our candidates. He was disqualified. And it was because he owed unpaid fines, so there was like no dispute. So there's nothing, Mr. Davis is citing Justice Viviano's or Justice Zara's writings on the order denying leave.
Right,
So
well,
there's like no analysis here.
Let me do
So-
this. Let me give both of you 8 days to file anything you want to file explaining Burton Harris to me. You don't have to file anything. You can
Sure.
rest assured I'm going to read it. But if either one of you wants, because I can tell you what's going on. I've got the things I have to do next week,
Okay.
but this will be coming out the week after that. I'm off in August. I know how time sensitive these cases are. I'm going to turn this around as fast as I possibly can. So if you get me something a week from tomorrow on Burton Harris, I promise I'll read it. But I don't want you to feel like you have to file anything. I'm perfectly capable of finding and reading Burton Harris and the Supreme Court order.
Yes.
That's up to you.
Thank you, Your Honor.
Okay, go ahead. Sorry.
All right, where to start? There was a lot going on, which I disagree with most of it, right? I mean, none of those cases that he cited obviously are Secretary of State cases, other than Roca. So we weren't part of those and we didn't appear in those. So if arguments are different now, if we're making a new argument, then the court can decide that some other precedent controls, but I don't think we are, because nothing other than Burton Harris has sort of said the secretary or filing officials have to dig behind and go look for a violation that doesn't appear from the record in front of them.
Right. Well,
So-
let me direct your attention to the two areas that intrigued me the most in what Mr. Davis told me. First of all, he says under MCL 168.558 subsection 4, there is a court process separate from the administrative process. Let's start with that one, then I'll ask you the next one.
Well, I don't see it. I don't see anything in subsection 4 that provides for a cause of action, right? There's nothing in there. There's nothing in there. And the arguments that we're making here today certainly don't undermine, don't wipe out any part of subsection 4, right? You can still, there will still be a person can file a false affidavit, right? It'll be obvious from looking at it or from looking in the campaign finance filings. That's neither here nor there. That's not what we have here, right?
Right.
So none of our argument really undermines any of the purposes of subsection 4, and sort of the language that was added about not certifying candidates who file a false statement. We've adopted an administrative rule, right, just recently, right, that says, like, when to determine whether they filed a false affidavit, you look at the campaign finance records,
And
right?
when you
That's
say-
168.2.
When you say an administrative rule, I presume this is something that's gone through notice and comment, and so it's valid under the
Yep.
APA.
Yep.
Okay.
Yep, they became effective in December 2022.
Okay.
So that is what all filing officials are directed to do, whether it's us or whether it's the counties. You
Right.
look at what's to determine the falsity of a campaign finance, their affirmation that they filed,
Right.
all of they have no outstanding reports or fines due. You look at the record, you look at the filings.
But
So that's the rule.
And just to be clear, I'm not questioning the legitimacy of the rule, but I think we can all
That's
agree.
fair because he didn't either.
Right. No, but I'm saying, I think we can all agree as a matter of administrative law that you can't promulgate a rule that's inconsistent with the statute. If a statute says something, the rule can't conflict with it.
That's true. We don't have a count like that here.
Yeah, I don't have any of these cases in front of me now, but I think I remember Mr. Davis making an argument, for example, that filling in that line that says, list the county where you ran it, and then the instruction says state, and it's supposed to be based on some regulation or something. That's a classic challenge where you can argue that a regulation is inconsistent with the statute and therefore falls, right? I'm not saying he's right or wrong on that, but that's the sort of thing under the APA that anybody can raise. They can say a rule is inconsistent.
Sure, of course. Yes.
Okay, right.
Anybody can
I'm not
make
asking you to concede that, but my counts.
No, right, yes, you could bring a count for
Okay.
that, right? But that's not what we have here.
Okay, can I ask you one more question?
Sure.
He also said that MCL 169.233 subsection 6, the filing and reporting requirements are self-executing. So in other words, it essentially is a gateway to a challenge in and of itself.
Well, it's only as self-executing as it is, right? All that means is that a candidate is supposed to know that they need to file reports, right?
But when I think of the term self-executing, I think what it means to me is it requires no additional reference to anything else. It creates a binding obligation that, whether you call it a private right of action or the ability to enforce, somebody has the right to enforce the violation of that. Now, you might tell me only the attorney general can do that, or I don't know what, but essentially what he's saying is MCL 169.233 parent 6 close parent is a standalone obligation, which requires no court has to consult anything else to figure out what the obligation is.
I think all it means is that the candidate is supposed to be self-aware and that they file campaign finance reports. I mean, it still doesn't alleviate the question here that there's been when the secretary looks in the campaign finance reports for Mr. Burton, there is nothing in there that indicates that he's out of compliance.
Right. And I clearly understand your baseline position on the merits here is your client did everything your client could possibly do to try to ascertain whether he was in compliance or out of compliance. After a thorough investigation, your client determined that he was not out of compliance. I won't say that he was in compliance, but he was not out of compliance, which rendered his affidavit legitimate. He could go forward as a candidate on that basis.
And even for the self-executing, I mean, you're still sitting here today, Your Honor, he's still asking you to make a determination that Mr. Burton is out of compliance, has violated the Campaign Finance Act. And that is solely a question within the Secretary's exclusive jurisdiction to determine under the campaign finance administrative process. The MICFA is specific that there is no private right of action to enforce any kind of violation of the Campaign Finance Act, and that it's her authority to determine and to remedy when somebody has violated that act. So I understand he's trying to he wants you to declare that there's been a false affidavit. It's only false if he's violated the Campaign Finance Act.
I understand what you're saying.
To make that determination.
So let's say that in his response, Mr. Burton, instead of writing as he did, and it was a little bit cryptic, not much, but a little bit cryptic. Let's say that he said, I ran for candidate in 36th District Court. As a candidate, I raised more than $4,000 through a GoFundMe account. I did not return any of that money to anyone. Now, we can all agree that that's out of compliance. You can't.
I'm not going to make any determination because
okay.
it's the secretary's, right? I can't either admit or
I got
deny
it.
anything, right? Because that is her decision. That is the
Right.
process to be used for
Yeah.
making a
And so
determination.
even if Mr. Davis were to come to the court with an affidavit from Mr. Burton admitting all the things I just said, I ran for the 36th district court. I raised 4,000 some odd change through a GoFundMe account. I did not file any campaign finance report in 2022. The hands of me on the Court of Claims or anybody else, any other judge in the state are tied unless and until the secretary makes a determination. Then he's got to come to the court to challenge the secretary's determination. And that's fine if that's your position.
Not really what we have here, right?
But I get it.
It's still the sole authority to make a determination that somebody has violated the Campaign Finance Act and to determine what the punishment or remedy is lies with the Secretary of State under the Campaign Finance Act. It's very clear.
Right.
And none of the other cases, I think, or the other statutes that Mr. Davis has cited gets around that exclusive remedy. And what we're talking about here, not all the cases that he mentioned are specifically about this very issue, this type of issue, but there's not an obvious error, on the face of the campaign finance reports themselves. So we are still a little bit in, I think, in uncharted territory on this particular issue, where there is no controlling authority that says somehow we're supposed to look behind everything when we make the determination at the time that he's filed the AOI.
Right.
That it's
right. I think one of the things
that
you're saying is his argument is losing sight of what the whole purpose of this AOI is supposed to do. I mean, it's just supposed to allow the candidate to indicate that they're, to the best of their knowledge, in compliance with all the obligations.
You can still be wrong. Like I could, if I file it and I check the box and I look and he's got $500 to, then he's made a false statement, right? I mean, there's some very obvious things. So, but I don't believe that the purpose, despite Mr. Davis's arguments, that this is intended to be used as a gotcha where you can go months after or later to find somebody an error in somebody's report and then make it something that they can be disqualified against, months later.
Well, it's not quite that, because if the Secretary of State looks at the record, it would see that he did not file a campaign finance report for 2022, right? I mean, I don't think there's anybody who's arguing that he did.
Right, because he had the waiver. Because he had the waiver.
He got a reporting waiver.
Right. So there was no report due. And that's what we go on when we.
I got it.
Yeah. It would be impossible to manage this process if there could be dozens and dozens of lawsuits over everybody who's made a mistake on a campaign finance report. There's an unpublished Court of Appeals opinion. It's Townsend versus, I can't recall, but it's just like that. He made a mistake on his campaign finance report that had the wrong address. That was not something that was a disqualifying factor, even though it was an error, on his campaign finance report. So I want to just then go back to the administrative process, because it's just absolutely not true that you don't get to a decision. You get to a decision. I mean, it says it right in there. I mean, a final decision of the secretary is subject to APA review, right? So that's if there's an administrative hearing. So if we make a decision.
Right, in which I help me out, because I want to get everything on one page. Which statute are you saying requires exhaustion of administrative remedies?
Well, I think the statute that would be, the case law says exhaustion of administrative remedies. It's subsection.
Are we in 168?
No, for campaign finance, you're in 169.
Oh, I'm sorry.
Yeah, 169.215. And subsection 17 is the section that says there's no private right of action either in law and equity under this act. The remedies provided in this act are exclusive means by which this act may be enforced and by which any harm resulting from a violation of this act may be redressed. So that's where you got no ability to privately enforce or seek outside of the campaign finance process a ruling that somebody is in violation of the act.
You seem to concede that Mr. Davis could bring an action once the administrative process has run its course.
I'm not, he could bring it. I don't know that it, I will argue, I'm sure that it's not properly brought. But conceivably, at the end of this process, right, if whenever with the secretary renders a decision, whatever it is, whether it's no violation, right, there's no violation, he could, well, actually, after that, if he disagrees with the secretary's outcome in the MICFA process, then it would be an administrative type appeal.
Okay. And so what you would tell me I should do in this case is dismiss counts 4 and 5 without prejudice.
I think you could do that. Because we don't exactly know what's going to happen at the end of the campaign finance administrative process.
It seems to me it can't possibly be with prejudice. Then even if the campaign, the administrative process runs its course, then presumably he'd be foreclosed from even seeking review of that, right?
Well, the MICFA process would be an APA appeal, which goes to circuit court. But to the extent he tries, then wants to do something from that over back in here, right?
But that's an interesting question, because it seems to me that the hotbed of all this litigation is the Court of Claims, not the circuit courts.
Right, but that's where APA appeals go to.
No, I know that, but that's one of the things that leaves me scratching my head, because so much of this election litigation winds up in the Court of Claims. And to the extent one can argue that you always have to exhaust under the APA and then pursue your remedies, you go to circuit court, you don't come here.
I think you only have to go, the only thing you need to exhaust is if somebody is asking that there be a determination that somebody, you can only conclude that somebody owes fees or reports if there's a violation of the Campaign Finance Act, right?
Agreed.
That's the only way, right? And so if that's what's needed to enforce Section 558, then yeah, that would have to be gone through the campaign finance process. But if the argument is that Secretary of State, somehow we messed up, we meant to look up Mr. Burton's records, but somehow we skipped over his, or we looked at a different candidate. We didn't see that he owed $500, right? That something like that doesn't have to be exhausted, right? It depends on the exact nature of what you're looking for.
Right.
When you're trying to get, a declaration that somebody is in violation of the Campaign Finance Act, that is something that would need to be exhausted. Otherwise, all these other, you certainly don't need to exhaust like non-MICFA things, right? That are part of the AOIs, right? Anything in the top part of like subsection, 5581 or 2, your citizen check box, the check boxes and all of those things, right? It's only if your argument is that this affidavit is false because he's actually in violation of the Campaign Finance Act, but nobody's said that before, like it's not obvious, there's not something on it, then that challenge needs to first be run through the MICFA process.
Okay.
Under the plain language of the statutes. Okay. I don't think I have anything else here.
Okay, thank you. Mr. Davis, you get the last word.
Very quickly, Your Honor.
Sure.
Again, I just turn this court's attention to these two cases regarding the administrative process with campaign finance. Citizens for Common Sense in Government versus Attorney General, 243 Mishap 43.
Yeah.
And Huron Valley Schools.
Yeah, these are the ones that you discussed extensively in your brief.
And in both of those cases, and that's why I taxed the example. This process, as the Court of Appeals have recognized, is not a decision by the Secretary of State because they use the word may be in violation. That, as a result, cannot be appealed, as the Court of Appeals has held in both of those cases. That letter you receive is not a final determination under the APA. That procedure cannot be invoked at all. And so when the Secretary says, file a complaint under the Campaign Finance Act, And you said, it means nothing. And the Court of Appeal says, if you want the court to have jurisdiction, to take action, request a declaratory ruling. And now they're saying,
You can't.
you can't. When you follow the procedure set by the Court of Appeals in this two published opinions, to say, if you want the court to have jurisdiction to review a campaign finance issue, first ask the secretary to issue a declaratory ruling under the statute. I did that. You have standing if they deny it, and you have the right to request them to issue it on an expedited basis, which I requested. And they denied it very quickly.
Right.
Per the precedent established by the published opinions, I have standing to appear before this court under their own argument. And this court has jurisdiction to proceed on the merits.
Right. And we don't need to do any more fact finding. We don't need to do any more discovery. In your view, you have factual predicate that Mr. Burton was a candidate, raised more than $4,000, and it doesn't even matter what he did on the back end.
That is correct.
That's the end of the factual context, and then it's just a pure legal question.
Pure legal question under five, because and I think this is important because I know some people are watching this. If the secretary's position is able to prevail, that means there could not be any other challenge based upon the truthfulness of a candidate's affidavit, because they said, nope, go through this process that means absolutely nothing, that takes 6 months. In which the Court of Appeals in two separate published opinions say that process is not a final determination that can be appealed, that your letter saying a person may be in violation, which is the language they use on that's why I attached it, so you can see exactly,
right.
That's not that process. And the Court of Appeals very clearly said, no, let's eliminate this nonsense. Here's the process. You want them to issue a ruling, request a declaratory ruling. If they deny it, you have standing to proceed, and the court has jurisdiction to determine the merits, which is precisely on two ends occurred. Under the whole, and what other case you need, which is helpful with respect to 168.558, in addition to Burton Harris, is the recent case that she and I litigated involving the judges. Davis versus, which is a published decision, in which, in ruling that latches apply, they said you shouldn't have waited. Once you got a copy of their affidavit, you should have ran to us.
Right. But I think that case is a little different.
It's a little different.
Right. The affidavit was invalid on its
face. Right. But on that issue, in terms of going behind, the other case is the Reed-Pratt case. Right. But I mean, right. And the fact of the matter is, Your Honor, even though she disagrees with Rocha, what Rocha holds is the fact that you had a candidate that on the date that he signed his affidavit, the filing fee wasn't due until 2 weeks later. Right. That was the issue. And the Supreme Court said, even though he had 2 more weeks to pay it, as of that date, it wasn't paid. And that's the same principle here, in which you have a candidate that had an obligation, self-executing obligation by his own admission, that he was required to file statements. Statements weren't filed. And now the Secretary of State saying, well, unless we say he needed to file them, there was no obligation. I said, but that's contrary to just the plain language of the statute, is that if you get 1,000, you have an obligation to report. There is no need for a determination. from the secretary, or
Well, I think we all agree, though, he did get a reporting waiver before the date the report was due. Now, I know that you said, I think it was a day before or something like that.
he received a reporting waiver with, I mean, and as the secretaries, there's no way for them to know whether or not it's true.
Right, but to be fair to him, I mean, he did get a reporting waiver.
He did get a reporting waiver, but the self-executing statute controls.
I understand. Yep. Okay. Fascinating. Yeah, sure. Go ahead. And I did want to say too, by the way, when you file your supplemental brief, if you do, you don't have to, but you may also talk about the Reed-Pratt versus Detroit City Clerk case, because that's another one that I was paging through earlier trying to figure out where these cases were, and I don't think that was in there either. So if you want to talk about Reed-Pratt, I'm going to have to look up and read Reed-Pratt, because Mr. Davis has now directed my attention to it several times. So of course I'm going to read it.
So just quickly on, the misreading of the Huron Valley case and the citizens and common sense. It's not even the process that we have here, because there wasn't, the letter that went out in Huron Valley was not a determination, right? It wasn't even it was not within the MICFA administrative process. Right. It was kind of this precursory letter. So we're totally different. And it doesn't matter, because if he's trying to go on the 263 and denial of a declaratory ruling, his jurisdictional ground is 24.264. He has clearly not pled a case or brought a case that gives him jurisdiction under that, because it's a very narrow, limited jurisdiction to appeal from the denial of a declaratory ruling, right? And that's explained in our reply brief.
24.264.
Right. That's all said in our reply brief, Your Honor.
Right.
So
I just want to make sure. I always try, when I come out of an oral argument that's really challenging like this one, everything I need to read should be written on this page so that I don't issue an opinion until I've run down every single thing on this page.
So I think his argument is that he has jurisdiction here to ask for declaratory judgment under 2605. So just sort of a regular sort of declaratory judgment standing. And I think that's where the argument comes in, that no, you don't, because we think it needs to be exhausted first. So that takes care of the 2605. If he's invoking jurisdiction based on the denial of the declaratory ruling, that vehicle is 24.264 under the APA, yep. And that's limited to this court can decide whether an administrative rule is valid or has applicability to a particular circumstance. And that's not what he's asking for here. So he doesn't have jurisdiction to that either. So I think.
Yeah. I have to say that I actually look forward to these oral arguments with you two, because you're both so incredibly good at it. So thank you. We've been at it for well over an hour and a half, and I've learned an enormous amount. I thank you both profusely. This is as well as this can be done. And I promise you, if you get your materials to me within 8 days, I'll have the opinion out to you within no more than 14 days. This is going to be project one. Next week's gummed up for me, but after that, this is project one. Okay. Thank you very much. It's a pleasure to see both of you. Now stand adjourned. Thank you, Jim. Appreciate it. Vicky, you have a second to talk?